Hello everyone, welcome back to my latest video. Today I would like to talk about an important law. This law relates to the time limit for filing suits in a court in India. It's called the Limitation Act of 1963. Even before this act actually has undergone several amendments before its final enactment in 63. Like there was the Limitation Act in 1908. Then there are even before that also some several limitation acts had been enacted during the British era. But and this was the final form, the final new act that was enacted in 1963. So far, there have been no major changes in the law in this aspect except for minor amendments here and there. So in this video, I would like to speak on the law of limitations in India, some key provisions and some relevant case laws. So moving ahead, so what is the main purpose of this act? Now it must be remembered that sometimes when parties file suits in courts, sometimes the matter relating to which the suits are filed is very old, and and the matter is almost irrelevant because of the passage of time that has happened. The matter becomes almost has become almost irrelevant. The parties can barely remember it. Not to mention the courts are heavily burdened with plenty of cases coming from time to time. So this is one of the reasons why courts usually take a long time for hearings and processing cases. And as the common saying goes, justice delayed is justice denied. So in order to fix the issue of long running cases and to ensure that whatever evidence is received during a hearing of a case is received and processed on time, then sometimes what happens is some parties they have an ongoing grudge against another party, and because they want to take revenge of some sort for some long ago issue, so they try to file a suit in court, thus unnecessarily harassing the other parties for no good reason. Then like I said earlier, when it comes to long going cases, if the case has been going, if a case is filed after a very long time after the events have occurred beyond a reasonable amount of time, evidence that was gathered during the time of the event or something, or during the process of investigation of the case, that evidence would have gone stale, would have become irrelevant, or would have become vague. So again, what happened because of the if a unreasonably long amount of time has passed between the happening of an event and the filing of a case in a court, so law evidence could end up being lost or modified or destroyed during that time. So the case could collapse because of that. Then if the matter is was a long ago matter, and there is no real reason to bring it up again, but some vindictive parties decide to bring it up to harass the other parties, that is also an abuse of law. And they are relating to this historical grievances, essentially grievances which have no bearing on present day matters, but some parties feel the need to settle it for reasons of their own. So again, essentially what happens is the courts, it is a waste of the court's time to saddle them with all of this stuff. So that's why the law of limitation exists, where the law specifies that if any event happens, you have to bring it to court within a specified amount of time after the event has occurred, a reasonable amount of time, to ensure the freshness of the case being heard, to ensure that any evidence gathered is presented to the court on time, processed on time, and justice is rendered quickly. As they say in, there is a common saying which says, justice delayed is justice denied. So this law helps to ensure that justice is delivered as swiftly as possible. Most as to what is the period of limitation, as in what is the maximum time period within which suits can be filed for cases. that depends on case to case basis, what the type of case is. The law has designated different time periods for different sorts of matters and cases. That we will look ahead further. So moving ahead, so under section 3 of the Limitation Act, it specifies that if any if matter is brought up before the court and the court finds out that that matter has been time barred because of the Limitation Act, that is whatever period of filing from the date of event has been specified by the Limitation Act, that period had passed long back. Under section 3, the court is required to mandatorily dismiss that suit, even if neither the defendant nor the plaintiff, obviously not the plaintiff, but even if the defendant does not bring up the limitation defense during the proceedings, you are allowed to bring up the limitation defense if a case is going against you. But even if the defendant does not bring it up and the court finds out that the suit is time barred by the Limitation Act, the courts are mandatorily obliged to dismiss the suit. They can't entertain it further unless, of course, the party, the plaintiff, provides a sufficient reason as to why there was a delay in bringing about the suit. Then the court can take the matter on board. Otherwise, section 3 mandates compulsory dismissal of said case. So in the India, so again, I have explained the reasons as to why limitation is important. So this section ensures that judges of courts, they should act as gatekeepers. Essentially, they should ensure that only those grievances which have been filed within the time period specified for them are brought before the court. Any case which has been filed after an unreasonably long amount of time, after the limitation period has passed, those cases are not brought forth, thus ensuring that justice is rendered as quickly as possible, and that parties make sure to file cases on time seriously, that they take the judicial system seriously. That said, this section, while the act bars the remedy before the court, as in what this act says is that if a case is brought before the court and the court finds that the time period for filing the case has expired, then the court is obliged to dismiss the case. That does not mean that the underlying right beneath the case suit is invalid. Essentially, the court can choose to dismiss the suit, but it can also pass an order, decree or order stating that the whatever matter is underlying the suit, if that matter is enforceable by law, if it is a plaintiff's legal right for anything in that matter to be enforced in favor of him, then that right of his should be enforced. That right should not be rendered unenforceable simply because the suit was time barred. So that said, even though section 3 is makes clear that Limitation Act requires compulsory dismissal of time barred cases, section 27 however acts as an exception to this rule. Now coming to section 27, says essentially section 20 when it comes to section 27, I'll talk about it talks about something called extinguishment of property. Now what is this what does this section talk about, that I'll explain further. So moving on ahead, so under section 5, although section 3 states that time barred cases are required to be compulsorily dismissed, section 5 provides that the delay in filing the case beyond the time period specified can be condoned. There is a specific procedure for condonation of said case, and for the court to take on even time barred cases. So what is there are 5 steps in this procedure. step number one, what the plaintiff, whoever is filing the case, he must file a request, uh, an application really. He must file an application for condonation of delay along with the main appeal, or if it is not an appeal, if it is a petition itself, you are filing that the case is being heard for the first time, then either that or appeal, an application for condonation must be filed, where the plaintiff is required to provide sufficient reasons as to why there was an unreasonable delay beyond the time period specified in the act, which is where the second step comes in. In that case, the reasons for the delay must be explained, and the focus must be made on the time. I mean, the let's say basically the delay beyond the time must be focused on. Let's say if the limitation period was say 3 years, in most cases it is usually 3 years only from after the time of the event relating to the case has occurred. So after 3 years, let's say you file the case after 4 years in total. So you must explain the reasons for the delay beyond 3 years. You must explain the additional 1 year, what happened within that additional 1 year due to which you could not file the case on time. That's what you should, your reasons must focus on, that additional 1 year or additional 2 years or anything. Then once you file the application, the court will obviously scrutinize, they will examine the reasons, they will find out if the reasons are genuine. In Latin we call it bona fide. If the reasons for the delay are genuine, like the genuineness could be if the party had been under a life-threatening illness or something which sustained for a long time, like years-long hospitalization due to which case just could not be filed in time, or party had been undergoing imprisonment during that time. Imprisonment often acts as a severe bar to filing case, although you could still do it to your advocate if you are imprisoned. Then if you aren't aware of the limitation act, but the counsel on who are fighting on your behalf gave you wrong advice, or essentially one of the bona fide reasons could be either a mistake of your counsel, or if any order has been passed by the court or by high court or supreme court or anything, where which you have genuinely misinterpreted the period allowed you to file an appeal or such, and if the court would take all of that into consideration. So that way the court would ensure that justice is not denied simply because of simple errors. If the errors were genuine, if the errors were beyond the plaintiff's control, then the court would ensure that justice is not denied to him for genuine reasons. Then once all of those reasons are scrutinized, the court would then condone the delay. Of course, every you make a mistake, even in daily life you make a mistake, you are required to pay for it. So here also, even if you made a genuine mistake, the court would condone the delay but would ensure that you paid for the delay. Some legal cost would be imposed on you. That way the equities basically between the plaintiff filing the case and the defendant, who has also been made to suffer because of the unreasonably long amount of time taken in filing the case before the court, essentially ensuring a significant delay of justice. So by imposing legal costs, there would be a sort of balance between the plaintiff and the defendants, plaintiff and the defendant in the case. So here it is called balance of equities, and that way it would ensure that even the defendant is somewhat compensated for his time wasted in the delay it took to file the case, or if he has suffered any injustice in the meantime, and so on. Then once the matter is condoned, there would be a final hearing. The matter is accepted like it would be if the case was not time barred, and the hearing of the case goes on as usual, as it would in a normal case. So moving ahead, that said, there are certain time exclusion rules. There are certain sections which provide for this. First is section 12. So section 12, in section 12, the certain days are excluded while calculating the limitation period. So what are the days excluded? For instance, if in an original case a judgment has been passed, and you are not satisfied with the judgment, and you want to file an appeal before a higher court, so or you want to apply for revision of such judgment or review of such judgment before that very same court where the judgment was passed. So essentially the day on which so as so day on which the judgment so certain days would be excluded here. Days would be the day on which the judgment was pronounced in the court regarding the which the appeal is being filed, or regarding which review or revision of the case is being done. So the date on which the judgment was pronounced, and if after the judgment was pronounced, then if you have applied for a copy of the judgment, then the time which the court takes to provide the copy of said judgment to you, even that time would be excluded. So essentially under section 12, if you are filing an appeal, or if you are filing a revision or review of the original case either before the same court or before higher court, the date of the final judgment pronounced, as in the date of pronouncement of final judgment, and the time required for the court to provide a copy of the judgment or decree to the plaintiff. If the plaintiff has requested for such copy, all of that will be excluded. Then another exclusion rule is section 14. Now under section 14, there is a thing that sometimes litigants, they are not aware of the proper jurisdiction of the courts. Courts have jurisdictions regarding which cases they should entertain, they can entertain. So under section 14, if there is a matter and a litigant or plaintiff has filed a case in one court, and the court has been hearing that matter for a long time, but during the case it comes out that the court didn't actually have the proper jurisdiction to entertain the case, and the court dismisses it. So obviously the plaintiff aggrieved goes to the right court and files the case again. So under section 14, the time during which the wrong court, as in the court not having the jurisdiction, was entertaining the case, and the litigant had bona fide cause to believe that the court hearing the case, the original court hearing the case, had the right jurisdiction, then the period of limitation would exclude the time period during which the original court was hearing the case. Provided, of course, the applicant was doing this in good faith. If it comes out that the applicant was deliberately doing this as a delaying tactic to frustrate the other party, as a sort of vindictive tactic, then the benefit of section 14 will not be available. Then under section 4, what happens? Also there is a protection. Under section 4, what happens is, let's say if the limitation period of one particular case is 3 years, and the limitation period has expired, the limitation period has expired during the day on which the court had a holiday. Let's say if it was a government holiday, and government holidays are usually holidays in which the court is closed. So if the court was closed during a government holiday, and the period of limitation happened to expire on that day, then section 4 allows the case which had expired on said day to be filed on the immediate next working day during which the court opens again. So again, this is another protection that is provided under the Act. So essentially, these three rules ensure fairness, as in that essentially under section 12 it is understood that if you want to file an appeal, or if you want to file a review or revision of a case, then obviously you need the judgment. So the date of the judgment pronouncement would need to be excluded, since obviously that's the day the judgment became known. Then the court often takes its own time to deliver a copy of judgment if you applied for it. I mean, you need a copy of judgment if you have to file an appeal or review or revision before court. So again, to ensure fairness, this is this period is excluded. Then under section 14, like I said earlier, litigants are often not aware of the jurisdiction of courts to entertain cases. The law is pretty complex in that aspect. So again, fairness is ensured by protecting litigants from honest mistakes, or essentially mistakes of fact. Then section 4 also is a protection, that is, the limitation period expired on a holiday, obviously it's not your fault that the court was closed on that day, so you couldn't file the case. So a concession is allowed you to file the case on the next working day immediately. Of course, on the next working day immediately, not the working day after that or after that, to ensure that you take your case seriously. Then all of this relates to a clause called bona fide. Essentially, these three sections, particularly section 14, ensures that you have genuine reasons for whatever delays you have incurred while filing the case, or that these delays were not really part of a malicious and vindictive tactic to frustrate the other party or to waste the court's time. Uh, to ensure something happened to engineer the case in your favor. So then section there under section 18, there is a section 18 says that if before the expiry of the limitation period for filing the case, if one party has signed a written acknowledgement where he has acknowledged his liability or any such due against the aggrieved party, the party which is about to file the case, then a fresh period of limitation would be computed from the date of the signing of such written acknowledgement. So what are the requirements to ensure that such acknowledgement signed is proper? One, the acknowledgement must be written. It must not be an oral one. It has to be in a proper written format, and it has to be to ensure that the court recognizes it. In law, evidence which is written, which is in printed form, that is usually the evidence the court recognizes. So here also the acknowledgement has to be properly written in a proper format. Then the signature on the acknowledgement must be made by the party against whom the claim is being made. Essentially, if you are a plaintiff and you are claiming something from another party, that party has to sign an acknowledgement where he acknowledges his liability with respect to the plaintiff. Then another requirement is this acknowledgement must be made before the expiry of the limitation period. Now obviously there is a thing called time bar debts, where essentially there is a thing where even if a debt is barred by limitation, you can arrange for the debt to be paid to you by a legal acknowledgement or sub. That's what this talks about. But that said, the requirement also says that the limitation, if the limitation period was say 3 years from the time the loan happened or whatever debt was incurred, the acknowledgement must be written and signed before the expiry of said limitation period. Once this is done, then there would be a clock reset, as in a fresh limitation period would start from the date of the signing of said acknowledgement. Then moving ahead, then I talked earlier about section 27. Now what does section 27 talks about exactly? Extinguishment of property. Now here it's section 27 essentially deals with the concept of legal and effective ownership really. So this section says that if you are technically the legal owner of the property, but someone has been occupying or staying on your property for a very long time, like a very long time, beyond what is deemed reasonable by the law, and you being the actual legal owner have not had any objections for such period of time to the other party occupying said land, then under section 27 the law would states that you would the other party who has occupied the land would be entitled to the ownership of the land which he has occupied, even legal ownership to be sure. Essentially, if you section 27 penalizes the original owner for taking too long to do something about illegal occupants on his land. So section 27 mandates that you must take action within a reasonable amount of time if you want to reclaim whatever land has been illegally occupied by other people which belongs to you. So there are distinguishing points between section 3 and section 27 here. So under section 3 the effect of limitation is that beyond limitation is the remedy is barred, as in there is no legal remedy, but the right which the plaintiff has to anything which is to the underlying matter of the case, that still remains. So you can still have your right enforced through other means even if the legal remedy is barred. But section 27 is far more punishing, where the right itself is extinguished. The section essentially punishes you for not essentially the section punishes you for not enforcing your right even after a reasonable amount of time has passed. So and regards the scope of each or both of these sections, section 3 usually deals with matters relating to money, as in loans, debts and so on, and of course and contracts in general, whereas section 27 exclusively deals with possession of land, as in it essentially deals with the immovable property, that is land of whoever has the right to said land. Then adverse possession of whatever of the matter of suit or property or such. Under section 3 adverse possession is not a core right, which meaning that if you want to if you have a right to anything and the other party has taken adverse possession of said matter against your will, you can still have your right to that matter and to that subject matter enforced against the other party. But under section 27 adverse possession is almost a prescription, as in the other party has illegally been sitting on your land and you are required within a reasonable amount of time to contest said illegal adverse possession. If you don't, then the possession automatically passes to the other party. You lose all right to it. Then what is the result of delay? Although in section 3, although the legal remedy is barred, you can still opt for legal settlement outside the court. You can still have the court would be obliged to enforce that settlement. If you come to a settlement with the other party, that settlement is legally binding, even if the court itself cannot entertain the suit due to the limitation limit. But under section 27 it is far more punishing in that matter, where it states that the title itself passes on. Essentially, as I said earlier, the right itself becomes extinguished. Whatever title you had to the land, that title itself is completely gone, completely lost. You can do squat about it, really. Meaning the section 27 is a deterrence to lax, to being lax about enforcing possession of your land against illegal entrants. So essentially you are required to reclaim possession of your land as soon as possible to ensure that you do section 27 is not attractive. Then section 3 is more of a procedure, as in and a limitation act has prescribed that courts are required to dismiss cases compulsorily which are time barred to ensure that parties take cases seriously, or to not unnecessarily waste the court's time on our long outstanding matters which have been outstanding for unreasonably too long. Then under section 27, so it is mostly about certainty of land, as in it is mostly about ensuring that land remains in the that you take charge of whatever land rightfully belongs to you from people illegally staying on it. Essentially, section 27 ensures that you take your possession of land very strictly, very seriously. Now, well, there are limitation periods are different for different sorts of cases. There is a schedule to the Limitation Act which has prescribed different limitation periods for different matters. So, matter number one relates to money suits or contracts, as in this mostly relates to loans or other sorts of monetary debts or contracts. Contracts, as in contracts for sale of goods or sale of securities and so on. So the limitation period is in case of in case of loans or dues or debts or other sorts of contracts. Limitation period is 3 years. So, so 3 years. So, what is the starting point? When does the limitation period starts? The limitation period starts from the day if you entered into a contract with the other party and the other party ended up violating that contract or causing a breach of said contract. The date when the breach occurred, or the date when you came to know about said breach. Then when it comes to loans or dues or debts, the day from which specific amount became due. Let's say if it is a periodic loan, then the date from which the first installment became due, or interest became due, and so on. Essentially, the date from which the dues first started accruing. Then next type of suit is suits for declarations. Now, what is suits for declarations? Suits for declarations relates to enforcing whatever right you have to a subject matter of the suit, which the other party has violated, or which the other party has stolen from you. So, what's the limitation period here? Again, it's 3 years from the date the right has accrued to the plaintiff. If relating to any subject matter, the right relating to that subject matter has accrued to the party, and the other from that date onwards, the limitation period starts. Then other is tortious liability. This mostly relates to any action for which you can take civil action. Tort means any sort of offense under civil law. This usually means breach of contract, or any other crime under civil law which is not covered by criminal law. So again, limitation period is, it differs. Sometimes it is 1 year and maximum is 3 years. A minimum is 1 year and maximum is 3 years. Again, it differs on the basis of the type of tort. So starting point is again when the injury or damage has occurred to the plaintiff. or if the plaintiff wasn't there or wasn't aware, the date he becomes aware of said injury or damage. That's from the time the limitation period starts. Now, the limitation. Now, for the next type of cases, the limitation period is somewhat higher. When it comes to immovable property like land or buildings or anything, let's say you want to file a, if let's say you want to file an action for recovery of immovable property. Let's say you had a flat or piece of land and you mortgaged it in exchange for a loan. Now you paid off that loan and you want to recover the land or flat or any building that was mortgaged to the other party. Then what is the limitation period for this? It is 12 years. And what is the starting point of such limitation period? Starting point is the date of adverse possession, as in from the day when you fulfilled the loan, as in you fully repaid the loan, but the party still continues to hold on to said property without returning it. From that date onwards, the limitation period starts, essentially adverse possession. Then when it comes to foreclosure by mortgagee, as in the party to whom you mortgage the property, and if for instance you have not paid the dues for a long time and the mortgagee decides to redeem the debts by selling off the property, so again there is a limitation period for filing a suit for recovering said foreclosure, said property foreclosed, and that is 30 years. The limitation period is the day the money becomes due, as in the day. Okay, I should amend my statements here. Foreclosure by mortgagee means you have a certain some property was mortgaged to you by other party who took a loan from you, and he has not been paying the dues for a long time, and you want to sell off the property to redeem the debts. So you decide to file an action against the other party to recover loans from him, or because you don't want to sell the property, you want to give it back. So the limitation period is 30 years. The limitation period starts from the day the money becomes due from the other party, the first installment or interest or anything. Then the other two actions relate to appeals to the to higher courts. Like let's say there was a case in a lower court, let's say district court, and you are not satisfied with the judgment of the district court, you want to file an appeal before the high court. So the limitation period for filing an appeal before high court is 90 days, and starting point of this limitation period is the date of the order or decree or judgment passed in the lower court, district court really. Then when it, again there are courts below district courts as well, like there is court of sessions and so on. Let's say if there is a court below the district court and you are not satisfied with the judgment, you want to file an appeal before the district court. Limitation period is much lower here, it's 30 days, again from the date of decree or order or judgment passed by the other court, the lower court. Then setting aside an award. This relates to arbitration really. Let's say a case was going on in an arbitration forum, and an award ended up being passed by the arbitral tribunal or arbitrator, and you are not happy with the award, you want to set it aside. So again the limitation period here is about 3 months. The 3 months it starts from the date the award was made by the arbitral tribunal or the arbitrator. So this is all about the different limitation periods for different types of cases or different types of matters. Now there are several case laws I would like to talk about, one or two. Well, one of the latest case laws was Pathapi Subba Reddy. This happened in the year 2024. So this was essentially a Supreme Court ruling on Section 5. Apparently under as I've already talked about, under section 5, there are certain cases where if the court decides that there is a sufficient cause for delay beyond the limitation period, then you can allow, then the court would condone said delay by charging costs to the plaintiff, and then the case would go on as normal. Now it depends on the discretion of the court in question, based on whether the court decides your reasons are genuine or not. So the Supreme Court had ruled on this. So the Supreme Court had addressed that the discretion of the courts in condoning long delays, especially when it comes to land. Apparently, this had been a matter relating to land acquisition. So when it comes to acquisition of land, the Supreme Court had addressed that there are limits to the discretion of the court in condoning long delays in filing cases relating to matters regarding acquisition of land. So appellants, apparently the case had apparently been dismissed by the lower courts due to due to the cases being barred by limitations. So the appellants, they had filed an appeal before the Supreme Court where they had argued for a liberal interpretation of the clause sufficient cause of delay specified in this section, and they had cited that establishing right of property regarding to land takes an extraordinarily long amount of time. So the court should condone the delay which is perfectly reasonable because of how long it takes to establish property rights. So the appellants argued that the court should disregard the legal niceties and focus on the substantive matters in issue. So what had been the solution here? While examining the case, the court had prioritized scrutiny of party conduct. Essentially, the courts had strictly scrutinized how the parties had conducted themselves when the case had been ongoing in the lower courts, and the Supreme Court had distinguished between diligent efforts. Like if you really were genuinely aiming to establish a right of property, then you should have pursued it diligently without unreasonable delay or laxity or negligence on your part. Then and which I said, diligent efforts, there is a difference between efforts made diligently, made with sincerity, and there is a difference between negligence, which is extremely visible when you are seeking delay condonation. So after a long hearing, the court had ruled that even if you had sufficient cause for not filing the case within the limitation period, it does not excuse negligence in filing the case properly within the time limit, or if your reasons were not genuine at all to begin with. Even if the court argued that the court laid down that even if the appellants argued for liberal interpretation of the sufficient cause specified in the section, it does not mean that you can abuse the provision as and when you want. It has clear boundaries to prevent said abuse. So this judgment had affirmed the core principle of section 5, while at the same time laying down clear boundaries regarding delay condonation to ensure prevention of abuse of said section. Then another case law was Sabu Matthew versus State. Again, this had happened in 2024. So this section, this primarily centered on section 14, which I had earlier talked about, pertaining to the condonation of, pertaining to the exclusion of the period where the case had been ongoing in the wrong court for bona fide reasons, when you when you finally take the case to the correct court. So when the petitioner found out that he had been fighting the case in the wrong court and the court had dismissed that case, when he filed the case in the correct court, the petitioner sought to exclude the time spent in the wrong court from the limitation period. So essentially, if the petitioner wanted to ensure that if he had been filing the case in the wrong court, fighting the case in the wrong court, when the wrong court dismissed said case, when he finally took the case to the correct court, he wanted the period of time spent fighting in the wrong court excluded from the limitation period for filing in the correct court. And he wanted that and he had supplied legal justification for delay. So what had been the solution here? So the correct court which had heard the matter had evaluated that if the initial prosecution of the case in the other court had been pursued with good faith and due diligence without any awareness of the lack of jurisdiction of the other court, and that it had not been some sort of tactical choice for delay, or it had not been some form of vindictive or malicious tactic to ensure a delay of justice or to harass the other party, then essentially the court evaluated all of that. So the court reaffirmed that at the end of the hearing, the court mandated that section 4 is a mandatory relief. Essentially, section 14 specifies that sorry, I should have said section 14, not section 4. The court mandated that section 14 is mandatory, that if the party who had been litigating in the other court had found out that that court did not have the correct jurisdiction and took the case to the other court, then the limitation period for spent in the other court, then limitation period is requires to exclude time spent in the first court fighting the case. However, the exclusion of the period spent fighting the case in the first court needs to be excluded only if specific conditions are met. Essentially, that, like I said earlier, provided the case is fought with good faith and with due diligence in the other court, as in for genuinely legitimate reasons, the case was fought in the first court without it being some malicious or tactical choice to ensure the frustration of the other party or to ensure delay of justice. So this section ensures that while protection of genuine litigants who had been fighting the case in the wrong court earlier, while at the same time deterring people who were misusing section 14 but deliberately filing case in the wrong court even when they knew it was the wrong one. So this section ensures that legitimate legal errors are protected. If you have committed a legitimate legal error, then you would receive the protection necessary under the law. That said, the case also established that the burden of proof regarding what sort of motives you had for fighting the case in the first court in the first place, it rests on the plaintiff. The plaintiff must prove that he had genuine cause for fighting the case in the first court, that he had no ulterior motive, that he wasn't making some tactical or malicious choice for like delaying justice or frustrating the other party while fighting the case in the first court. So essentially, the court you need to provide genuine reasons if you want the protection of section 14. So when it comes to Limitation Act in section Limitation Act, there have been some ongoing trends which have changed the avenue of limitation. One, when it comes to digital records, everything is digitized nowadays. So courts are also now increasing, are accepting digital signatures. They are accepting emails and records which are cloud based softwares. Now section 18 specifies written signed acknowledgements. Now increasingly nowadays courts are accepting online documents which are digitally signed, emails or emails which have the parties acknowledgement with essentially the parties details downstairs, the the sending parties details. Then records which are cloud based, cloud based, all of these are being accepted now. Then there is a relationship between section 5 of the Limitation Act relating to condonation of delay and section 238A of the Insolvency and Bankruptcy Code. Essentially the correlation has confirmed that the limitation law now applies to insolvency as well. So essentially there is a time period here also. There's a time limit specified here which says that if a company is being dissolved, being liquidated, then the date of the liquidation, about 3 months from the time the liquidation starts, that sort of period would be the limitation period for filing a case relating to insolvency. So again, IBC compliance has now proven a thing. Then as in like I said, the date, it starts up from about 3 months from the date of liquidation or the date the insolvency was declared. Then there is also ambiguity or vagueness persisting whether there are now Limitation Act specifies the period of limitation for certain cases, but there are certain local laws as well, state laws you could say, which specifies their own limitation periods. So the Limitation Act here has established a compromise which states that if the period of Limitation Act conflicts with the limitation period specified in the local law and the local law limitation is shorter than the period specified in the Limitation Act, then okay, let me amend that. If there is a conflict between the period of limitation in the act and the period of limitation specified under state laws or other local laws, then the period of limitation specified in the local laws or state laws would be taken as the limitation period under the act. Apparently courts are still split on whether to take the Limitation Act limitation period or the limitation period specified under the applicable local or state laws. There is still a conflict, but the act itself specifies that the limitation period of the local laws or state laws will be taken as limitation period of the act. Then when it comes to arbitration law in 2025, that there probably might be a Supreme Court ruling which would specify the limitation period for international commercial arbitration, as in it would specify what is the period for which uh, essentially international commercial arbitration relates to disputes between one party in India and the other party which is a foreign party located outside India. So obviously there would be a conflict of laws. The limitation period specified as per foreign law might be different from that specified in Indian law. So again, if such cases should come to international commercial arbitration and it is held in India, the seat of arbitration is in India, what would be the limitation period for such type of arbitration? There might be a Supreme Court ruling in there probably was a Supreme, we are still waiting on a Supreme Court ruling there. I think there was a Supreme Court ruling, I'm not sure, but regardless of whether there was or there has yet to be a Supreme Court ruling, there is no definite period for international commercial arbitration yet, so we still have to wait upon that. So concluding this video, when it comes to Limitation Act principles, we need to remember these key principles. one core section is section 3. As I said earlier, the courts need to are required to summarily dismiss cases which are barred by limitation, even if the defendants do not argue the limitation defense. Then, however, under section 5, thus time barred cases can be taken up by the court, provided the proper application and sufficient reason is given by the plaintiff for the delay. Then section 12 and 14, as I said earlier, it provides for exclusion of certain days and periods spent in, let's say, spent in awaiting judgment or spent in awaiting copy of judgment from other court, or under section 14, fighting case in the wrong court for genuine reasons, that period would be excluded, and so on. Then section 18 talks about clock resets. Essentially, like I said earlier, if you have signed a written acknowledgement where you have acknowledged a liability or due to the other party, then a fresh period of limitation would start from the day of signing of said acknowledgement, provided the acknowledgement was signed before the limitation period, the original limitation period, was over. Then section 27 is essentially a punitive section which talks about how your title to a land would be extinguished if you did not take action against someone illegally staying in your land for an extremely unreasonably long amount of time, beyond which you fail to take action. Then the right to said land, the legal title to said land would automatically pass to the other party. So the Limitation Act is really a vigilance standard. The Limitation Act is essentially a deterrent to ensure that you take whatever case is against you very seriously, that if you have a grievance, then you get it redressed on time rather than waiting for too long, that you take whatever grievance is against you very seriously, and that you are vigilant enough to seek justice at the proper time. There's always a proper time for everything, they say. So this section, the purpose of the Limitation Act is to ensure that you seek justice at the right time, that you do not unduly wait for long simply because you want to reap certain undue benefits out of the delay, that you take the law very seriously. So this is all about the Limitation Act. I thank you all for watching this video. I hope this video is proved sufficiently enlightening to you all. I hope this by this video you have all learned, you all hoped that whatever cases are required to be filed against whoever party you have grievance against, you file the case against the court on time, that you do not be lax and you do not wait for too long, and you do not try to take advantage of undue delays, since the courts will definitely not let you take advantage of undue delays. So if you have any case, if you feel like filing cases for any grievances you have against anyone else, make sure to do so within the time specified under the Act, or even below within the time specified under the Act. Just make sure to file cases as quickly as possible to ensure limitation is not attracted against you. So once again, thank you all for taking the time to watch this video. Please watch, like and recommend this video to anyone else you know. Please subscribe to my channel at Siddharth Bhatt 4898 where this video is at for more of my videos. Please also subscribe to and recommend my channel to anyone else you know. Once again, thank you all for watching this video. Thank you all for your time. Thank you.